Hi everyone, this is Lily. I am a social worker for Child Protective Services, also known as CWS, DCSF, CWS. I'm making this video to kind of give a little overview of the system. Child Protective Services is an agency, at least here in the United States, that we go out to people's homes to investigate reports of abuse. It's run state by state. Here in California, it's by county. So we get laws from the federal government and the state, and they're interpreted by each county, and each county comes with their own procedures of how they're going to address these issues. The legal standard that we use to determine if abuse or neglect has occurred is not the same one we use to determine if we're able to take the kids out of the home or not. It's two completely sections of the law. One is the penal code, and the other one is the welfare and institutions code. And again, I'm in California, so this might be different in other places. So whenever we get a call into the hotline saying, I believe this child is being abused, we would generate a report, assign it to a social worker to investigate, and we go out and see if the situation that's going on matches with the penal code. The child is being physically abused, neglected, emotionally abused, sexually abused, tortured, being affected by the abuse to another sibling. So we have to make a determination as to whether abuse has occurred or is very likely to occur, based on the circumstances of the family. And this assessment is done per child. So it's likely that we're only able to say abuse has occurred to this one kid, but not to this kid. Depending on the situation, depending on the age of the youth, depending on what's going on. Sometimes parents are scapegoating one particular child, but these siblings are at risk because of the abuse of the other sibling. That's one of the sections in the law as well. So they might not qualify under one or the other, or there might be different perpetrators to different types of abuse. Whatever it is, that's a child by child assessment based on the circumstances of the family. We have about 30 days to complete the investigation. If at the very beginning, if we find the child's safety is in danger, we would either go to request a warrant for removal right away, or if it's an urgent circumstance, we would remove that same day and then go to court within 48 hours. If it's not something urgent, we try to work with the family, try to stabilize the situation. We have those 30 days to figure out, can we put some resources in place to make, so that the family can figure it out on their own and close that investigation? Or do we need to open a case because the abuse has occurred and the parents are just not able to do it on their own? When we open a case, it doesn't automatically mean that the children are coming out of the home. We are able to open cases with children remaining in the home if we're able to safely accommodate that. It is not our goal to remove children. It's our goal to make sure children are safe. Depending on the type of abuse, depending on the severity, voluntary services we do when the parent understands there's a problem and wants help to fix it, and they're willing to work with us for 6 months or more. We don't go through court. It can be in home or out of home depending on the situation, and the parent is willingly agreeing to this. When like I said, if it's a more severe situation or the parent doesn't agree, they don't think they need help, then we go to court. And again, a court case can be with the kids in the home or out of the home. Where I work, we call family reunification when the kids are out of home, and family maintenance when the kids are in the home. So when we decide we do need to take a case to court, what we do, that initial worker that's investigating writes the full court report explaining the circumstances, why we need the court to intervene, what have we tried to stabilize the family, because we have to demonstrate our efforts. It's not just like we're worried and the people don't want help. We have to say, what have we tried as the social services agencies to help this family? So we would have to say, they got resources to therapy, they got help with rent, They were set up with babysitting. We had therapists set up. Whatever it is that we try to do to help them, we would have to describe those efforts. If we try to get a family involved, we have to demonstrate efforts to find any missing parents. So if the kids only live with mom, we have to show that we try to locate the father. What efforts? We also have to talk about what efforts did we have if we have to remove the children, that we notified relatives and we made efforts to place the children with relatives rather than foster care. So that document gets reviewed by the agency attorneys, the attorneys that work for the county, to make sure that we're meeting all the legal standards. So when we get the okay, the attorney types up the petition. So this is what the whole case is based on. So they write up the legal language. They write up, Welfare and Institutions Code 300 ABCD, whatever it is. Let's go with the example where the one child is being physically abused. So the oldest, Jimmy, would be 300A. The younger siblings that are not the ones being physically abused, but we believe they're also at risk, because if we remove the scapegoat child, then any of them could be the next one. They would be 300J. Once they write that up, then we send it to the court, and then we go to court the very next morning. If we had an emergency removal, we would have to provide to court the information of where the kids are. If we are asking for the warrant to remove the children, the judge will sign it that same day, and then we go to court the next day. All the parents, the children, and everybody gets assigned an attorney. The judge makes a determination whether the information in the petition is sufficient. They're not saying whether it's true or not. They're just saying if this information was true, would this be enough to remove these children? So at that time, they give us like temporary custody, and we come back in 3 weeks with more information, more in depth, more follow-up, so that we can then demonstrate that yes, it is. So the very first court is the detention hearing. The next one in 3 weeks is a jurisdiction and disposition hearing. That's where we go into the whole history of everything. We have 3 weeks. We talk to them about where were you born, who was your parents, your siblings, how was your childhood, were you ever abused as a child, did you ever experiment with drugs, anything that could be an issue, so that we can formulate a good plan of how do we help you best address your kid's safety. So in this court hearing, if everybody's in agreement, the judge agrees, signs off, orders whatever we're recommending. Most of the time, the parents are not in agreement with their case, with the kids being taken away or a case being opened. It does happen, very rare, because again, a lot of parents don't want their kids taken away. From then, they give us a trial if not everyone is in agreement, and we come back with further evidence. Sometimes we have to testify to why we believe this information is correct and why does it pose a risk to the children. That's where the judge orders the case plan. The case plan gives the parents goals and services to reach those goals. So one of the goals we have, do not show that you will not be abusive to your child, but demonstrating you're able to provide appropriate discipline. And we'll give some examples like, write 5 ways that are appropriate for the age of each of your children that you can discipline them without physical force. How are you going to be able to tell that you're losing control of your anger, and what are you going to do if that happens? Whatever. We'll come up with examples depending on the circumstances. And then the next section is where we give them what services are going to help them to meet those goals. So some counties, some states go by the services that they go to the class that was ordered for them. We go by, are they meeting their goals? Are they behaviors showing us that they are making changes in their life? A good example for this is substance abuse. It's not a matter of whether they graduated a program or not. It's a matter of if they're living a sober lifestyle. And I often tell my parents, you can abstain from using for 6 months, for a year. That does not mean you're sober. if you're still hanging out with people that use, if you're still letting your spouse drink in the home when you know you're an alcoholic, and that's just a recipe for disaster. It's the ticking time bomb. That's not living a sober lifestyle. A sober lifestyle is not associating with people who use, having a sponsor, having a support system, knowing what your triggers are, knowing how to identify them, and who are you going to call for help if those triggers happen. So there's a difference, and those are the things we're looking at. It makes it a little bit more subjective, but it makes them more accountable. So after that court, once these things are ordered, that's when the case makes it to my program, where we do the follow through and make sure that they are enrolled. They should have already been enrolled, but if they haven't, we set it up. We do the progress reports, check in with them monthly, the kids, the parents, the foster parents. A lot of the times we have to constantly keep re-engaging these people into their programs, and we just monitor everything, whatever concerns come up. The parents go to classes, the kids are either in foster care with relatives, or in the home with the parents, and I monitor their progress, the children and the parents. One of the things that I personally like to ask a lot of my kids, what's something that your parent needs to learn? And is your parent demonstrating this to you? Have you noticed a difference now that your parent's going to classes? For babies, babies up to 2 years old, the parents are guaranteed 6 months of services. Children 3 and up, the parents are guaranteed 1 year of services. It can be extended. That's just like the bare minimum. If the parents have made enough progress, we can ask for the children to be returned home. We try to make it not match to a court. So we ask permission for us to make that decision. A lot of times they tell us, yes, you can do it with the agreement of the minor's attorney or the kid's attorney. We try to not make it match to court exactly, so we can have a little bit of a trial period. Because once the judge says it, it's an order. So one practice that we try to do is to try to get the family ready about 60 days before we go to court. It doesn't have to be exact, but just so that we have a trial period where we say, we used our discretion to give you more, we can use our discretion to take it back. Once the judge orders it, it's an order. We can't just make our minds that we're worried. We would have to start that process all over again, that abuse has occurred, that there is something going on, and ask the judge again for a removal order. Whereas if it's a trial period, we can just say, no, let's reverse this trial and put more safety in place before we make it an order. For the most part, we keep the case open for another 6 months to monitor that things are in place. And once they are in family maintenance, I don't believe there's a minimum or maximum. We keep, if there continues to be concerns with the family, we keep extending it. In my experience, the longest I've had one of those cases was 18 months. The maximum for reunification is 24 months. The goal is 12 months. We don't want children to be in foster care longer than 12 months, and that goes based with the day that they were removed. The court timelines, 60 days from the day of removal or whenever the plan was ordered, whatever is soonest. But the court generates that date for us. So a lot of times from the 12 month to the 18 month, it's not exactly 6 months. There are some exceptions in the law where we can bump it from the 18 to the 24, only if the person has been incarcerated, hospitalized, or institutionalized. So that's like a rare exception. I've only used it one time in my whole career. And it was for a parent that was incarcerated, and she was able to do her classes while she was in prison, and she was released like a week or something, like before court, where the 18, where her max would have been. We were able to extend it, and she got her kids back. That was the case that I've had the longest, and I've had that case for close to 3 years. So that was my little summary. I guess no, let's keep going. So what happens when the parents don't get their kids back? If at the 12 or 18 month, they're not able to demonstrate they've made enough progress, they're still using drugs, they're still not understanding appropriate discipline, they're still engaging in violent altercations. they're still dating the perpetrator of abuse. What we do first is say, your time to reunify with the children is over. You're not going to get help from us anymore. So that's what we're terminating. We're terminating their reunification services. We would recommend what a permanent plan for the kids would be. So at that point, we have the option to say the kids are in a stable, loving home that's willing to adopt them. Let's in this case do adoptions, or the family is willing to do a legal guardianship, which is, they would have custody until the kids turn 18. Or there is nobody that's willing to adopt or provide legal guardianship for these kids, and then the plan would be, I'm not sure what they call it now. We used to call it long-term foster care, but I know it changed because legislators didn't want it to be like a final plan for the kids. They want us to constantly be looking for permanency for the kids that remain in foster care. And then also one of the changes that's been not so recent, but I mean, I've been around forever. It wasn't a thing when I was when I first started, was extended foster care. So kids can stay in foster care until 21 now. It's completely voluntary once they turn 18. If they want to stay with the same foster family, the foster care payments would continue, I believe, like a portion to pay the rent, to pay for their expenses. If they get like an apartment, they get the rent paid. If it's gonna be legal guardianship, they don't lose their parental rights. They only lose the parental rights if it's going to be an adoption. So if the recommended plan is adoption, or if they're not sure which one they prefer, we send the case over to an adoptions unit to do that. It's a very specialized process, and this whole process could take, I think it's about 2 years. If the parents are present and opposing to everything, it can take a while. In that time, the parent hasn't lost their rights. They still have a right to visitation with their kids, and they are still able to, without the help from the social worker, they could still do their classes, pay for it on their own, and demonstrate to the court that they changed their circumstances. That's a way that they can get the kids back outside of that reunification period. When the case goes to legal guardianship, the legal guardianship unit takes the file but then sends the case back to us so that we can continue to do the regular case management, visiting the kids and all that until they get the paperwork set up. This process is more like 6 months. And when it's long-term foster care, we just keep it. Another couple of specialized units we have is the residential unit. When children's behaviors make it unsafe for them to be in a foster home level, we do have higher level of care, therapeutic level foster homes, or treatment centers. Those cases go to those units. We also have medically fragile units. So when kids have a lot of medical needs, they go because they require more attention to make sure that all their needs are being met medically, as well as their whatever the reason for their case. And we also have a specialty unit, a specialty Indian unit, because there's separate set of laws that apply when children have Indian ancestry and are registered to a tribe. Back in the day, if anybody had any concern for abuse for any kids on our caseloads, we would be the ones to investigate. But recently, because there's been a lot of concern for that area specifically, our county made a special investigations unit. It will get assigned to one of those workers, but they will consult with me before they go out. So they will ask me, like, what have you seen? Have you had any concerns? We get a lot of false accusations about foster parents when the family is angry. And a lot of times we get a lot of true allegations or real concerns. So I would be the most indicated person to know, like, do we have concerns? Or this, do things look up to standard when you go visit every month? I think those are the ones that I can think of now. So this is like a complete overview of the whole system. Thank you for sitting through. If you've made it this far, thank you for taking the time. See you at the next one.